podcast lecture series. So, yes, a very warm welcome to all of you to a fresh season. And of course, it's a moment of great pride that we wrapped up the first season of Codecast lectures very successfully. And now, to start a brand new season of Codecast, we thought what better topic to talk about than learning the basics of civil suit. And who better than Mr. Ghulam Jeelani, who is an advocate, who is a senior advocate practicing at the trial courts in Srinagar, primarily with civil matters. And I have a personal affinity for Mr. Ghulam Jeelani as well, because probably for my first case, I had a case against him. So I owe a lot that I have learned in civil law from him, from his pleadings especially, because at that time I didn't used to ask him a lot of questions, but I would read his pleadings, and I assure all of you that I learned a lot, and I'm sure from his experience and his learnings in civil law, we all will benefit today from the lecture. So without much further ado, I welcome Mr. Ghulam Jilani to deliver the lecture, and of course, just for the sake of abandoned caution, we just reiterate the format of our lectures. This series is there's a lecture for half an hour or say an hour, depending upon the topic, of course, and the depth and the range that the speaker wants to give to the topic. Then it will be followed by an interactive session wherein all participants would be encouraged to ask questions and have healthy discussions on the topic. So I hand it over to Mr. Ghulam Jilani for the lecture.
Assalamu alaikum, all my fellow participants, and very good evening. A very important lecture has been assigned to me by my fellow associate, Advocate Fahad, that are the steps pertaining to the institution of the civil suits. If we broadly divide the steps, there are a number of steps which a lawyer needs to be initiate for filing of the civil suit before a court of law. But before proceeding further for the steps which we have to initiate, I will just demonstrate the stage which is much more important than the institution of the suit before the court is the stage when a client approaches the advocate for institution of the suit, and there comes a pre-institution stage. And this pre-institution stage is a very vital and lays down the foundation for a lawyer, for a litigant in order to enforce his right before the honorable court. So important aspect of the civil suit is a right. A right gives a person a license to approach a civil court. But a right should be that right which has been violated. So, on mere apprehension, there is no license for a person to approach a civil court where the person apprehends. So, the violation of the right is a sine qua non for institution of the suit. As we all know, being associated with the legal fraternity, that this right flows from a very important maxim, which is a very important maxim in the civil law adopted by the Indian civil system from the English civil system, that is ubi just ibi remedium, meaning where there is a right, there is a remedy. So the right is a consideration, precedence for a person for approaching to the civil court, but right should be that right which has been violated. So the first and the foremost important ingredients for institution of a civil suit is the right which has been violated and against which a person approaches to the honorable court for its enforcement. there is a vast difference between the CRPC and the CPC. In CPC, there are certain provisions where mere apprehension on the part of the party gives a right to the party to approach the civil court. But in civil courts, there should be a violation of the right which are vested in a person who sought indulgence of this honorable court. So the party is the first step. There should be a party as mentioned in the order 1 is the very vital which starts our journey before the court of law for filing of the civil suit. Parties is the procedure governing the parties is given in order 1, which says that there should be a party who is aggrieved of the acts or the omissions on the part of the other persons. So once the party approaches, he has to show that there is a violation on the part of the other side. That is why I am before the honorable court, because I have a right, the other side is having the liability. So the honorable court adjudicate upon the rights and the liabilities of the parties. On the one side, we say that a person who approaches the honorable court is also known as a plaintiff. In Urdu, we say muddi, and in Hindi, we say wadi. A person who approaches before the honorable court for enforcement of the right is known as a plaintiff, and against whom he sought remedy before the honorable court for enforcement of his right and enforcement of the liability is known as a defendant. In Urdu, we say mudalih. So initiation of the suit begins with the journey to file a suit begins with the filing of the plaint, by virtue of which a plaintiff comes before the court for enforcement of the rights. But before filing the suit, a primary duty is imposed upon the plaintiff to ascertain whether the plaint which I am going to file is a competent plaint or not, whether any mischief rule is not coming in the way of filing of the suit. Mischief rule is that we have a very important section in our CPC, that is section 9, which provides a remedy to every person to approach a honorable court for enforcement of his right, provided that there is a bar. Bar is that if there is any statute which bars a person to approach the honorable court, then the plaintiff cannot file a suit before a court of law if there is a statutory bar to approach a civil court. If there is any other remedy provided by the statute for enforcement of the right which has been violated, then the person cannot approach the honorable court. There are other bars. For example, we have a bar of res judicata under section 11. If a person has already filed a suit and the competent court of law has adjudicated upon the rights and the liabilities of the parties and has also passed a judgment, then we cannot reopen that case. There is a totally bar upon the parties as far as section 11 is concerned. Before section 11, there is a section 10, that is the matter which is already sub judice pertaining to the same cause of action in between the same parties. Then there is a bar of filing of a fresh matter before the honorable civil court. There is one more bar, that in case a suit which a person intends to file comes within the mischief rule of a limitation. So we don't have to read only the CPC for filing of the initiation of the suit. We have to ascertain the other legal impediments which are in the Limitation Act and other remedies. For example, sometimes a statute has been passed by the legislature whereby special authorities is given to the particular court to adjudicate upon a particular matter. So there is a bar of a statute as provided under section 9, that a person cannot file a suit which is statutory bar. If a person has already filed the suit and there is a proper judgment passed by the proper court in between the same parties pertaining to the same matter, then the person cannot file a fresh suit. And if there is a suit already pending disposal before the competent court, we cannot file. In that case, the judgment is yet to be passed by the competent court, the matter is sub judice. So we cannot file a fresh suit pertaining to the same subject matter. And more so, if a person had already filed a suit and he has not contested that suit, and that suit has been dismissed in default, there is a bar under Order 9, Rule 9, that we cannot file a fresh suit pertaining to that matter. So these are the bars which a person who intends to file a suit has to ascertain, because in case a suit will file tomorrow, we file a suit without ascertaining the pre-institution bars, then there would be unnecessary delays is the main cause of the delays is that these things which we don't follow while filing the suit, and we do not ascertain these things at the pre-institution stage. So as far as these things are concerned, we have to ascertain these things first of all, whether there is any impediment pertaining to the filing of the suit in order to enforce our rights before the honorable court. So the first and the foremost important aspect is there should be a parties to the suit. Parties to the suit is provided under Order 7, but I will not read only the Order 1, because parties to the suit depends upon the person who approaches the court, whether he is a natural person or a statutory person. Sometimes there are the persons who have a legal infirmity, who cannot approach the court directly. Legal infirmity means a minor cannot approach a court on his own. Being a minority is a legal infirmity on the part of the minor to approach a court. In that eventuality, the honorable competent court appoints a guardian pertaining to the matter which is correlated with the minors. And there may be sometimes a lunatic. There is no bar for a lunatic to approach a court, but there is a proper procedure to be adopted by the courts, by the person who intends to approach on behalf of the lunatics. So we have to read Order 1 with other orders, which includes the orders which are Order 32 and 30 pertaining to family matters. For appointment of the guardians, we have to ascertain these things first in order to approach the court. So Order 1 is not the only order which governs the parties to the suit. We have to read the other orders also. So we knock the door before the honorable court by filing of the plaint. Filing of the plaint is the first step which the person undertakes for filing of the suit. A plaint as defined under Order 6 and Order 7. Order 6 and the Order 7 specifically mentioned the contents which should be enumerated in a plaint for institution of the suit, which means first of all we have to choose the forum. A forum is the very important before whom we approach for the enforcement of the right. Forum as given by the CPC is the forum which has a jurisdiction to adjudicate upon the matter, which includes place of suing. That is section 15 to section 20A of the CPC governs the place of the suing of the case. We have to sue the case before a court who has a jurisdiction to adjudicate upon the matter. Place of suing means where a subject matter, jadadi mutadawiya, falls or where the defendant lives or works for the gain. So place of suing is provided under section 15 to section 20A of the CPC, which provides a stage for a person to institute a suit. Once we institute a suit, then the court ascertains whether suit is a competent, where the suit has been followed, where the contents of the suit is a competent to be adjudicated. So in case the honorable court finds that the suit is not a suit which should be filed before his court, then there is a provision under Order 7, Rule 10, returning of the plaint to be filed before the competent law. So the competency of the court is a very important in order to file a suit. Or in case there is a lack of cause of action, there is an improper court fees attached to the suit, then there is a provision under Order 7, Rule 11, rejection of the plaint. Plaint can be rejected. So the pre-institution stage is a very vital for the institution of the suit, where the lawyers need to be work very hard in order to give a smooth tiding of the suit. Once our suit is entertained by the Honorable Court, first and the foremost duty of the Honorable Court is the issuance of the summons under Order 5. Issuance of the summons against the defendants, against whom the plaintiff has approached before the Honorable Court with a complaint that the defendant has violated my rights. So Honorable Court, in order to secure the presence of the defendant, issued the summons. Defendant may be a person or a statutory body, it may be government, or it may be any firm, company, corporation, against whom the plaintiff has filed the suit where his rights have been violated, where the indulgence has been sought by the plaintiff for enforcement of this right. So once the Honorable Court issued the summons, then comes a doctrine, RD alteram partem, which is a very important doctrine of our law, because no person should be heard, condemned without hearing him. So Order 5 is a natural right. It is a natural right of every person that once any allegations has been made against person, there is a provision under Order 5 which gives a powers to the Honorable Court to secure the presence of the defendants in order to answer the questions which has been raised by the plaintiff in his plaint. Once the plaintiff comes before the Honorable Court, he has a right to rebut the allegations as leveled by the plaintiff in his plaint. Then what he did, he followed the mandate of law and files the written statement. Written statement meaning in Urdu is a jawab dawa. There is other options before the defendants as far as the order. This is the Order 8. Order 8 is concerned. Once the plaintiff files his written statement, he has the option to file a counter claim or set off. For example, a plaintiff files a suit for enforcement of the right, but at the same time, he also violates the right of the defendant. So the law gives option to the defendant to file a counter claim against the plaintiff itself without filing a fresh suit. In order to avoid the multiplicity of the suits and in order to avoid the multiplicity of the judgments passed pertaining to the same subject matter and in between the same parties. So counterclaim is a right of a defendant to defend the suit which has been filed by the plaintiff. Or there is one more option before the defendant. It is in addition to the written statement as provided under Order 8. The defendant has a right to file a set-off. Once a counterclaim is filed by the defendant against the plaintiff, counterclaim itself is a plaint. So then the plaintiff has a right to file a replica. In Urdu, we say Jawabul Jawab. Replica is the answer to the counterclaim which has been preferred by the defendant in addition to the written statement under Order 8. Sometimes a situation may arise that the plaintiff didn't choose to come before the Honorable Court despite acknowledging the summons as issued by the Honorable Court under Order 5. There may be a number of situations which may arise. For example, the defendant did not choose to cause his presence before the Honorable Court, or causes his presence, or in other eventualities, the plaintiff himself failed to cause his presence. Then there are the consequences. Consequences of the appearance and the non-appearance of the parties. Consequence, in case the defendant appears and files the written statement, then there comes the other stage. In case the defendant fails to cause his presence, despite acknowledging the summons properly, then the court has the option to proceed in ex parte against the defendant, meaning thereby the suit of the plaintiff will proceed ahead. without hearing the defendant. Without hearing the defendant, because an opportunity has been granted to the defendant to cause his present and he answered the questions which has been raised by the plaintiff, but he has failed to avail this opportunity. So court will not wait for the defendants. As in criminal cases, we have seen that once the criminal did not approach the honorable court waits for him. He issued the warrants. Here, there is no provision of issuance of the province as far as at the stage of causing his presence. Only the honorable court will ascertain that the services has been executed in a proper manner. There is a manner and the mode provided by the order filed to the suits, how they should be served. And second situation may arise that the plaintiff remain absent and defendant will cause his presence. Then the honorable court may dismiss the suit of the plaintiff for non-appearance. And in case the suit has been dismissed or has ex parte proceedings has been initiated against the defendant, then there is one more option before the parties, before the plaintiff. He can file a suit for restitution of the suit after showing the reasonable cause of his failure to cause his presence before the court of law. Or the defendant may approach the honorable court for setting aside of the ex parte which has been initiated by the honorable civil competent court by showing the reasonable cause. Reasonable cause is a vast term. So without going into that, let us proceed further, because my topic is the steps in this civil suit. Once the written statement has been filed by the defendants within the statutory time. Statutory time given is 1 month at the first instance, which can be extended up to the 90 days thereafter, after the defendant will cause his presence and file a motion for extension of the time. Extension of time is a discretion of the honorable court. When the honorable court finds that there is a reasonable cause for the defendant, that he has not prepared the written statement within the statutory period of 1 month, then the honorable court may extend the period of, but not beyond the 90 days. This is in order to curtail the delays. Once the written statement has been filed by defendant, then comes the stage where the honorable court may examine the parties under order 10 in order to ascertain the main controversy in the parties. The purpose of the order 10 is that whether there is any scope for reconciliation in between the parties, especially in those matters where the parties are correlated or where the parties belongs to the same family. Though the honorable court prefers the reconciliation mode after examining both the parties. After, in case the honorable court finds that there is no scope for reconciliation in between the parties, then the honorable court proceed ahead. Comes the stage where the honorable court ascertain the contents of the written statement. If there is an admissibility of the contents of the plaint, there is an admission, voluntary admission without any force or a fraud, the honorable court has a power to pronounce a judgment on the admission of the defendant under order 12. So the order 12 gives a powers to the honorable court to pass a judgment on the admission made by the parties. We have to read this admission in consonance with the other law, which is the Evidence Act. We have to see that the essential ingredients of the admission has been fulfilled. It is not a mere saying that I have filed a written statement, I have admitted this claim of the plaintiff, the court will pass the judgment on the admission. A duty is imposed upon the court to ascertain the admission in light of the section 17 of the Evidence Act. Order 12 will come into play in order to ascertain that this is a legal admission. This is not under force or under coercion that the parties is making the admission before the honorable court. In case the parties did not admit the claim, then there is a one more step whereby the honorable court framed the issues. Framing of the issues falls under order 14. The honorable court frames certain questions upon which the burden is shifted upon the parties who asserts or who denies the allegations and the counter allegations. As we all know that the issues are of three types: issues of facts, issues of law, and issues of mixture of facts and the law. So the Honorable Court, while framing the issues, has to verify the pleadings of the parties. Pleadings of the parties here is plaint, written statement, and the documentation, plus the statement which has been made by the parties. After fully ascertained, scanning the pleadings of the parties, the Honorable Court frames the issues. Issues may be of fact, issues may be of the law, issues may be a mixed question of fact. Then at this stage, the courts ascertain that in case there is a scope of framing of the issues pertaining to the law, that is to be adjudicated first. In case as my suit falls within the ambit of mischief rule of the limitation, so I have to convince the Honorable Court that this suit, which has, if I am on the behalf of the plaintiff, I have to convince the Honorable Court, no, my suit doesn't fall within the impediment of the limitation, or I have a cause of action. I have a valid cause of action. Cause of action, as we know, is the bundle of the things. I have a cause of action upon which the court has a powers to fix the rights and the liabilities of the parties, adjudicate upon the rights and the liabilities of the parties. Then the court, first of all, gives its finding upon the facts of the law. That is very important. In case the courts did not give any findings upon these legal issues, which we say as are the preliminary issues, ibtidai tanqihat, then in the long run, a very long time will be get wasted, and money will be get wasted. Very important time of the courts may be get wasted in case tomorrow the suit will fail. In order to cut short the controversy at this juncture, the court has a powers to reject the plaint or dismiss, even dismiss the suit under section 151, read with the section 9 of the CPC, whereby there is an impediment in the way of the plaintiff to file a suit before the court of law. Then comes a stage where these issues had been framed and the burden has been shifted upon the parties to prove these issues. In order to prove these issues, the court gives an opportunity to the parties to adduce evidence. Evidence means direct or indirect evidence. Direct evidence means that I am relying upon certain document, that I am relying upon certain statute, I am relying upon certain articles, I am relying upon the statements, so I can brought those persons before the Honorable Court. Again, there is a proper procedure for securing the presence of the witnesses as enumerated under Order 16. Order 16 provides the procedure whereby the Honorable Court secures the presence of the competent witnesses before the court of law, and the opportunities are given to the plaintiff as well as defendant to file an application whereby he can sought indulgence of the Honorable Court, assistance of the Honorable Court in order to secure the presence of any witness before the court so that he can depose, whereby we have to deposit the dietary expenses of the witnesses to whom we are intending to secure the presence in order to prove our claim. So Honorable Court issues the summons, or there is an option before the parties to secure the presence of these witnesses on their own. Once the plaintiffs lead his witness or secure the presence of the witnesses by seeking the indulgence of the Honorable Court in order to prove the issues which has been earlier framed by the Honorable Court, whereby these burdens has been placed upon the plaintiff as well as defendant. Once the witness situation is over, I will mention one more aspect. There is a order 16A inserted by way of the amendments, whereby the courts are having powers to secure the presence of the persons who are the witnesses but are under prison. So the court has a vast power in order to secure the presence of the witnesses, whether they are inside the prison or outside the prison. Order 16A gives the powers to the court to secure the presence. Once the witness part is over, then the parties thereafter argued the matter before the court in order to secure the reliefs. The plaintiff will request for the passing of the judgment, whereas the defendant will request the dismissal of the suit. It depends upon the nature of the suit, the witnesses which has been produced by the contesting parties, plaintiff as well as defendant. So thereafter, the parties file their arguments. There is an option before the parties either to advance the oral arguments or file the written arguments. After fully ascertaining the arguments, plaint, written statement, as well as the evidence which has been produced in supporting of their claims and the counterclaims, thereafter there comes the stage where the honorable courts pass the judgment. Judgment as provided under Order 20. What is the judgment? Judgment is the answer to the questions which has been framed by the Honorable Court in the shape of the issues. So, first, Honorable Court ascertains the plaint and thereafter the written statement, counterclaim, replica, documentation, and gives the finding upon the issues. Court is under there is an obligation upon the court, is a duty bound that to return the finding upon the issues which has been framed. Once the honorable courts gives it a judgment under Order 20, so there is a total explanation of the suit, explanation of the plaint, explanation of the written statement, explanation of the issues, as well as the other aspects which the courts fully enumerates under the judgment part. And after the passing of the judgment, the honorable courts take steps for framing of the decree. It is a decree which ends the struggle of the parties before the civil court, and it is a decree which gives a powers to any person in whose favor it is passed to seek execution. Execution is the second aspect of this civil CPC. Decree is the enforceable part of the judgment. So the judgment is a vast, voluminous enumeration, explanation of the court, whereas the decree is a precise summary of the judgment which the honorable courts passed in favor of the person. The person in whose favor the decree is passed is known as decree holder, and against whom it has been passed is known as the judgment debtor. These are the main steps as far as this civil suit is concerned. But during the pendency of the suit, there comes a situation where the parties approach the honorable court for passing of the certain orders which we known as the interlocutory orders. Interlocutory orders is very important because it protects the list. For example, if I file the suit for partition of the property and the defendants during the pendency of the suit take steps to alienate the property, so it has become important in order to protect the list, in order to protect the interests of the parties, to pass an interlocutory orders, darmiyani ahkamat. Interlocutory orders can be passed by the honorable court. First and the foremost, we prefer an application at the time of the initiation of the suit under Order 39, whereby the honorable court has a power to pass an ex parte injunction after dispensing the attendance of the defendant by virtue of another motion, and pass an order whereby the protection of the list has been enumerated, where the court finds that the plaintiff has come with the case and fulfills the three essential ingredients. Prima facie case, balance of convenience, and irreparable loss. Prima facie case means a case whereby there is a scope of adjudication. Balance of convenience is that in case injunction is not been passed in favor of the plaintiff, tomorrow some mischief will happens, that he will be non-suited, or in balance of convenience, irreparable loss meaning thereby it that the in case I withhold my hands and will not pass an injunction order, then there would be a loss which cannot be compensated by way of the money. So the honorable courts passes the interlocutory orders in order to protect the interest of the parties as well as protect the list. Order 39 is not the only order which gives powers to the courts to pass interlocutory order. There are other orders whereby the honorable court has a powers to pass the interlocutory orders, which includes proper power to appoint a receiver. The court has a power to appoint a receiver in order to protect the list, power to arrest the person before passing of the judgment, or attachment of the property before passing of the judgment. These powers are enumerated under Order 38, which gives powers to the Honorable Court to attach a property before passing of the judgment in case the court finds that the there is a need of an hour to pass an order which may protect the interest, which may protect the issue. So interlocutory orders can also be passed by the Honorable Court in order to protect the list. Similarly, the Honorable Court can also appoint the commissioners. Commissioners can be appointed under Order 27 in order to ascertain, in order to make an investigations, because the court is known as expert of experts. But the expert opinion is very vital sometimes in order to ascertain the real controversy in between the parties. So order, as far as the Order 26 is concerned, it provides a power to the Honorable Court to appoint the commissioners in order to ascertain, in order to verify the claims of the parties. Similarly, there is the Order 24, payment in the court. Sometimes we bring a suit whereby we sought indulgence of the Honorable Court for recovery of the money, and we have an apprehension that tomorrow the defendant will flee from the, so the Honorable Court can direct the defendant to deposit the money before the court in order to keep the rights of the parties in a safe zone. So interlocutory orders can be passed by the Honorable Court. These are the main steps which need to be taken by the lawyers before filing of the, which comes before the lawyers during the pendency, during the adjudication of the civil suit. With this, I am very thankful to all the participants for bearing me for this time, and also thankful to the Mr. Fawad for providing me an opportunity. This is a small step on my behalf in order to share my little knowledge which I have gained from the last more than 20 years before the bar. So thank you so much. Any queries?
Thanks a lot, sir. And one must also appreciate how succinctly you have put in brief all the stages of a civil, nearly all the stages of a civil suit as well as you could. Thanks a lot once again. Now we open the floor to questions. So those who want to ask questions may please raise their hands and unmute their mics and ask questions.
Assalamu alaikum, sir.
Walaikum salam.
Sir, thank you so much, sir, for such a wonderful lecture, sir. I have a small query, sir. Is there any difference between interlocutory orders and temporary injunctions, or are they just the synonyms? And can we file the application at any stage of the suit, or it is mandatory to file it at the time of institution?
Interlocutory orders and the interim orders are the synonymous to each other, and there is no bar for filing of these applications at any stage. But I will add one more aspect in this matter, that it is not only the plaintiff who has a right to file an application. A defendant can also file an application for seeking the interlocutory orders at any stage. Why we use the interlocutory and the interim orders? We have to put some labor upon that. Interlocutory orders include the orders which the Honorable Court passed while hearing the case on every day of hearing. Whereas why we use the interim application? Because we prefer an applications during the pendency or at the time of the initiation of the initiation of the suit. Is it okay, Mr. Ishtaq?
Yes, sir. Yes, sir. Yes, sir. So thank you so
Anything?
much, sir. Thank you so much.
Okay, so we'll wait for the next question, please. Yes, so we have a raised hand from Mr. Advocate Naik. Please ask your question, sir.
Assalamu alaikum, sir.
Walaikum salam.
Sir, my question is that if judicial officer, yeah, if a court has passed an interim order regarding status quo, wherein the judicial officer has mentioned in the order that status quo should be prevailed in the suit property, and if after passing the said order, if the plaintiff himself violates the order of the uh, court, whether the defendant can file contempt petition in the same court or in a high court.
First of all, we have to ascertain whether this interim order which has been passed has been made absolute or not. If it has been made absolute, there is a proper procedure, and if it has not been made absolute, there is a procedure, different procedure. If the order has not been made absolute, then the Honorable Court is having powers under Order 39, Rule 2A. If the status quo, which my brother is talking about, that the status quo order has been passed and the plaintiff himself has violated the terms and conditions of the order,
Obviously,
what would be
obviously.
the so is this the question, sir?
Yes, sir. Yes, sir.
If the plaintiff himself the violates and the order which has been passed at the times of the initiation of the suit, then the defendant has a remedy to file an application under Order 39, Rule 2A, which gives powers to the civil court to initiate a proceedings against the uh, guilty party. Here, the guilty party is the plaintiff itself. And in case the order has been made absolute, then the Honorable Court has to hear the contempt, refer the matter before the Honorable High Court under the Civil Contempt Courts Act. Is the question clear? In
The order has been the order has been made absolute on consensus basis from both sides of the learning council of the both sides. The matter is that the defendant had filed an application under section 155 to implement the order through concerned police. The concerned police visited on spot and recorded some statement from adjoining areas of the adjoining persons who
the
had
person who are
some
I
who
got
had
it.
some. Hmm.
So the
On
so
that
the
basis, on that report, the defendant filed. I am on behalf of defendant. The defendant filed on basis of the said report, which the concerned police has submitted before the concerned court. Whether the defendant can file contempt petition
yes.
before the same court who had passed the same order.
First of all, a satisfaction should be returned by the same court that there is a violation of the orders. But
Yes,
the
sir.
power to punish under contempt of act is vested with the High Court. So
Yes, sir.
the filing of the let you bear me for a while. The filing of the report by the concerned police, whereby it has been ascertained by the concerned police that there is a violation of the order, recording of the statements of the persons who are present on the subject matter is a matter of fact. So the Honorable Court, at the motion filed by the defendant, will sort the statement of the facts from the plaintiff. And thereafter, the Honorable Court, if the Honorable Court finds there is a violation of the orders, then the matter would be referred to the Honorable High Court for the proper proceedings. Any
Okay.
more
Thanks,
questions?
sir. Okay. Thanks, sir. Thanks, sir.
So, any more questions? Yes, we have another raised hand, sir, from Mr. Sheher.
Assalamualaikum, sir.
Walaikum salam.
Sir, first thank you for the beautiful lecture. Sir, my question is कि मेरा client है सर, उसका बैंक account freeze हुआ है, but there is no FIR against him, nothing against him. लेकिन फिर भी उसका account freeze हुआ है. उसने बैंक को रीजन पूछा तो बैंक वालों ने कुछ ऐसे टाल मटोल किया, कोई रीजन नहीं दे रहे हैं. सर, इज देयर एनी सिविल रेमेडी अगेंस्ट such an action by the bank?
I have started my lecture with the violation of the right. Right to maintain the bank account is a right vested with a person. It cannot be curtailed without following the due procedure of the law. Having FIR is not a condition for knocking the doors of the Honorable Civil Court. If your client feels that his right has been violated, here I say yes, his right has been violated. He has a right to seek remedy before the Honorable Court against the bank personalities. Not only the recovery of the this amount, but also he can file a suit for compensation for the damages which may have accrued to him for freezing of the account. More so, if we go through the banking this service, it falls within the ambit of the Consumer Protection Act. So there is a two remedies available to the your client. If he is aggrieved of any action done by the banking authority, he is a consumer, he can file a complaint before the Consumer Protection Forum, or he has an option to choose any proper civil court within the jurisdiction where the bank is located or where his business is located.
Thank you, sir.
So we have another question from Mr. Sheikh Saqib Ansari. Please ask your question, sir.
Welcome, sir.
Walaikum salam.
Sir, I have some question that the interim orders of the court, at what stage can we challenge these interim orders, or at what stage can we file an application for vacating of such orders?
My dear, if we go through the order 39, if the order has been passed in an interim application preferred by the plaintiff at the time of the initiation of the suit, the Honorable Court is under an obligation to adjudicate that application within a period of 13 days. It is a mandate of law as provided under 39. And in case the Honorable Court passes the order in any application which has been subsequently filed by any of the parties. For example, a need may arise, we file a suit for recovery of the possession of the property, certain property, and the plaintiff comes with an application before the Honorable Court that the defendant is taking steps for alienating that property before passing of the judgment. So he preferred an application under Order 38 for seeking attachment of the property. If the order is passed by the Honorable Court, then there is a schedule, proper schedule as provided under the Limitation Act. It is not only the CPC which plays a vital role for adjudication of the civil suit. We have to we have to seek the refuge of the Specific Relief Act. We have to seek the aid of the Limitation Act for taking certain steps. If the application has been preferred for passing and the order has been passed, and if the person is aggrieved, if the person feels that this order is not in my favor, or it has not been passed in accordance with the law governing the subject matter, then there are a number of options before the aggrieved person. Aggrieved person here may be the plaintiff or the defendant. He can prefer an appeal, but he has to see that whether my order which has been passed is an appealable order or revisible order, or there is one more review option before the concerned aggrieved person. If he finds that the order has not been passed in accordance to the law, or there is a judgment, certain judgment, which has not been ascertained by the Honorable Court while filing this application, he can seek a review from the same court. Review powers are vested with the same court. Within 1 month, he can file an application seeking revival of the Nazr Sani, jisko hum bolte hain. He can file an application for review, but he has to specify that the law has not been ascertained in a proper manner by the Honorable Court while passing the order. If he didn't prefer a review application, then he can file a revision before the Honorable High Court, because the revision powers are vested with the Honorable High Court within the period as provided under the Limitation Act. Or in case the order is an appealable order. For example, I prefer this plaint before the Honorable Court, and Honorable Court rejects my plaint without adjudicating the matter. The rejection of the plaint comes within the ambit, within the definition of the decree as enumerated under order section 20 subclass 2. So if there is a finality in any order, then the appeal powers is there. The appeal right is vested with the aggrieved party to seek the proper remedy which is available as per the statute, but subject to the condition that he has to approach the appellate court, he has to approach the revisional court within the specific time as provided under schedule of the Limitation Act. Is this clear?
Yes, sir. Thank you.
Sir, I have a question.
Please ask, sir. Please ask.
Sir, first of all, thank you for such a valuable lecture. सर मेरा एक क्वेश्चन है, जो आपने कहा रिटर्न स्टेटमेंट फाइल करने के इसका मैक्सिमम पीरियड 90 डेज होता है, पहले 30 डेज और उसको हम फर्दर एक्सटेंड कर सकते हैं 90 डेज, एंड अंडर वन सेक्शन 148 सीपीसी इसको हम फर्दर एक्सटेंड ऑफ टाइम कर सकते हैं, लेकिन वहां पे लिखा है नॉट मोर देन 30 डेज। लेकिन ऑफन टाइम्स आई हैव सीन कि 1-2 साल तक भी हम कभी कभी ये नहीं करते फाइल, और कोर्ट की डिस्क्रिप्शन पे हम नहीं करते, वो दे ही जाते हैं। अंडर ये कौन से लॉ के हम तहत हम करते हैं ये फर्दर एक्सटेंड जो हम टाइम करते हैं?
देखिए जी, पहले हम जो ये रिटर्न स्टेटमेंट फाइल करते थे उसके लिए हम सालों लेते थे। यहाँ पर वो मैक्सिमम आता है जस्टिस डिलेड इज जस्टिस डिनाइड। सो द लेजिस्लेटर फील दैट in order to curtail these delays, there needs to be an amendment in the CPC. So the amendment has been made under the CPC, whereby first of all, the time frame has been given, that is only 30 days has been given to the defendant to file the written statement. But the Honorable Court can extend the time up to the 90 days, but before extending the time, the defendant has to sought indulgence. It is not automatic. It is not an automatic that he had failed to file the written statement within a period of 30 and the 90 days has been given. He has to file a motion. He has to specify. For example, if I file the suit pertaining to the particular property, and the defendant will come that, no sir, I am the owner of this property, but the documents are not lying with me. I have approached the Mal Khana for the certified copy. This is the proof. This is my application. It is not possible for me to secure those documents within a shorter period. So extend my time. So Honorable Court has a power to extend up to 90 days. 90 days is the upper ceiling for this for filing of this written statement. Here you are saying that we face a number of situations where the Honorable Court takes years together, or the defendant takes year to file the written statement. These things happens in the court because curtailment of the filing of the written statement is a vital right. It cannot be curtailed, but at the same time the court has to be given way to the plaintiff's rights also. We cannot defeat the rights of that. There is a specific, but we are also having the one more judgment of our honorable High Court, whereby it has been reiterated that only 13 days time, it cannot be extended beyond the 90 days. Beyond 90 days, the right of the defendants should be closed. Right, sir?
Sir,
Hello?
judgment, sir, what is the title of the judgment? Can you please specify?
Justice Nagraj, Fahad, Honorable Kuchi Justice.
Okay, sir. I will look at it. Thank you, sir. Thank you so much.
Sir, there is another hand.
Adil.
Mr. Adil, please ask your question.
Assalamu alaikum, Jeelani sir.
Wa alaikum salam.
Then sir, I have got a case yesterday, sir, regarding a trust.
Okay.
Regarding a trust, that is
Yes.
that trust is registered under the Indian Trust Act.
Okay.
And my client has approached me with the opinion that one of the trustee in that trust has been caught manhandling. Trustee is located. It is a school.
Okay.
It's a private school at this Jawahar Nagar vicinity. And
Okay.
one of the trustee has been caught manhandling with some employees, and yet greed has prevailed upon him. He is doing illegal acts in the institution, and he is interfering with the smooth functioning of this institution. And moreover, by way of his illegal acts, a memorandum has been passed in the institution whereby there are all the trustees and all the employees are the signatory in that. So my
Okay.
client has approached me that with a view to restrain him from doing these activities.
Okay.
So my question is that do I need to file a civil suit for injunction restraining him from doing these activities, or do I file an application I have got through the Indian Trust Act, whereby I have
Mhm.
read with the section 34.
Mhm.
Section 34 says regarding any trust, if there is any opinion or direction, you may approach a civil district judge for
Mhm.
opinion or any such direction, except for filing a civil suit. So I
Mhm.
need to apprise by your good self. Do I need to file a civil suit restraining him, or do I need to file
There is
this application?
there is no restraint upon the person to file a suit against the trustees or the person who has misappropriated or who has violated the covenants of the trust. But first, you have to seek a permission first, because the suit against the trustees is governed by a special law. We have a two number of cases. We find two number of cases as far as our CPC is concerned. One category is the general suits. General
Yeah.
suits means a person who approaches against the person. But there
Yes.
is a special suits. So as far as this trust part is concerned, it comes within the ambit of special suits. Special suits here means summary suits, trust against the military persons, trust against suit against the firms, suit against the sailors. So you have to seek the permission, and you have to ascertain the first whether this is a private trust or a public trust. Right, sir?
This is a private trustee.
So private trust is governed by its own rules and the regulations.
Yes,
So you have
but
to. It is
according to the trust, these conditions and these
yes,
parameters.
yes. There should be a enumeration in the trust deed itself if there is any misappropriation
Yes, yes,
or the
yes, yes.
breach.
There is a violation on the part of that one of the trustee, that he has violated also the terms and conditions of the trust.
And the trust deed itself will have speakers about what would be the legal consequences.
Yes, 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 yes.
So you have to ascertain the contents of the trust deed first. Then
So so
in
so
case
I need to execute the trust deed.
execute meaning by I'm not getting. Execution has been already done.
I,
Is
I
the
need
trust
to,
deed is
but
the trust deed registered?
if I say that, if I said, for example, if I say that there is an violation of conditions of the trust, that
Okay.
trustee has violated the terms and conditions of the
Yes.
trust, what
Yes.
remedy is with me then?
Is your trust recognized by the government?
Yes, recognized and registered.
Okay. If
It is it is basically Oak Hill School.
okay, it is
Yeah.
done by the trust.
Yes, yes, it is run by the trust.
The trust deed is
So
there.
yes, trust deed is also registered. I need to say that, if suppose, can I file a civil suit
You have
restraining
to,
that
yes,
trustee, or
yes, yes. But only thing you have to take into consideration is that there should be a one para in your plaint specifying that you have to seek the indulgence, you have to seek the permission of the honorable court, because this trust is to be, this suit pertaining to a trust is to be gone through the deputy commissioner concerned. These are others. There is a statutory bar to file a case directly. So you have to ascertain, you have to sort the leave of the honorable court. One more judgment of our own high court, Ghulam
Mhm.
Muhammad Khuru. Ghulam Muhammad Khuru in SLJ 2002 to 2003. You can ascertain, you can see the aid of that judgment also.
Okay, sir.
Specific trustees. Ghulam Muhammad Khuru versus some Qadri. I don't remember at this time, but there is a
Okay, noted,
specific
sir.
direction. There is a specific direction to the parties pertaining to the initiation of the suit pertaining to the trust, because I have already stated that it's not only the order one which gives the mention, which mentions about the parties. There's other orders, for example order 33. Order 33 gives the powers to file the suit on behalf of the indigent person. Right, sir?
Mhm.
Same,
Yes, sir.
vested with these trusts. There are certain guidelines provided by these orders which is to be followed before filing a suit against any statutory body. Here, the statutory body is the trust, which is governed by the trust deed, as well as you have to see the permission from the competent court. It is
Okay,
clear.
sir. Okay, sir. Okay, sir. Thank you. Thank you, sir. Jeelani, sir.
Thank you.
Thank
There is another question from Mr. Sajad. So we'll let him ask the question, and I think that would be the final question of the day. Mr. Sajad, please ask your question.
Assalamualaikum.
Walaikum
Jeelani
salam.
sir, Assalamualaikum.
Walaikum salam.
I just want add one point
Mhm.
vis-a-vis that trust suit.
Okay, sir.
What I think is one person cannot file suit against a trust. There should be minimum 2%.
Yes,
This is
these are the conditions.
basically my question is regarding the set off. Can you please explain what's that set off? Just to give this, I am just giving this reference that one person cannot file the suit against a trust. There should be at least 2 persons. But my actual question is that what is set off? Can you please explain it?
Set off
elaborate?
is I will try to, sir, because we are all the students of I need to learn from you also. Set off, counterclaim, and written statement. All are given under order 8. For example, if I owe 100 rupees to Mr. Sajad and I file, if a Sajad owes 100 rupees to me, I file a suit for recovery of 100 rupees before a court of law. That is my right. Is that clear?
Sir.
And in
Please.
case Sajad will come tomorrow before the court of law, yes, I owe rupees 100 to Mr. Jeelani, but at the same time, Jeelani also owes me rupees 20. Please set off this amount from the suit, and then the suit will proceed.
Sufficient. That is sufficient.
Any more questions, Mr. Fahad?
Yes, sir. I think that would be all. And I was doubly sure of this thing that the interaction session would be very successful today, and rightly so, sir. Thanks a lot on behalf of the entire team of Codecast for giving such an elucidated lecture on such an important topic, sir. Thanks a lot. And of course, we'll welcome you to future lectures also.
Inshallah.
Thank you. Thank you
Okay.
for everyone for participating. Thanks a lot, everyone.
Assalamu alaikum.